On the outskirts. Especially on my job.
And Chair Thompson, that was correct. I looked further down in the docket and the major entered his appearance already, so we're good on that one. Thank you.
Okay, thank you. Clocks show different times. Okay, my computer shows 9:01 and it's synced with the satellite, so that must be accurate. I would welcome everyone to the meeting, the monthly meeting of the Water Quality Control Commission. I'm the chair, Bruce Thompson. We've got a pretty full agenda, although I think it's going to change. So at this point, I'd like to ask Ms. Jones to call the roll.
Good morning. Commissioner Armstrong. Commissioner Brankard.
Present.
Commissioner Candelaria, he did indicate he was going to be absent. Commissioner Dominguez.
Present.
Commissioner Fry.
Present.
Commissioner McWilliams.
Present.
Commissioner Patton also indicated he was going to be absent. Vice Chair Rader also absent. Commissioner Rosatos.
Present.
Chair Thompson.
Present.
Commissioner Velasquez.
Present.
Commissioner Vehil.
Present.
Commissioner Zemlik.
Present.
Chair Thompson, you have a quorum.
Thank you very much. I appreciate y'all showing up. If you're like me, it's nice to be in an air conditioned building. So second item on the agenda is approval of the agenda. Are there any suggested changes? I think I need a motion for approval.
Mr. Chair, I move the agenda be approved as presented.
Second. Moved and seconded. I guess this is a roll call vote. I'm a chair of another organization, and when we were meeting virtually, everything was a roll call vote, but simple things like agenda approvals or minutes approved by roll call. Okay. Mr.
Chair Thompson, let's continue with roll call votes, please.
Yes, thank you. We will.
Commissioner Armstrong.
Present.
Present, and you have approved the agenda? We'll come back around to you.
Yes.
Oh, that's a yes. Okay. Commissioner Brankard.
Yes.
Commissioner Dominguez.
Yes.
Commissioner Fry.
Yes.
Commissioner McWilliams.
Yes.
Commissioner Rosatos.
Yes.
Chair Thompson.
Yes.
Commissioner Velasquez.
Yes.
Commissioner Vehil.
Yes.
Commissioner Zemlik.
Yes.
Motion passes.
Third item on the agenda is approval of the minutes of our last meeting, which was sent out this week, I guess. Have a chance to look at them. Motion to approve the.
Second.
Commissioner Rosato, was that you?
Armstrong.
Oh, I'm sorry. Okay, Commissioner Armstrong, you moved, and Commissioner Dominguez a second. Thank you.
Any discussion, modifications? Please call the roll.
Commissioner Armstrong,
Yes.
Commissioner Brankard,
Yes.
Commissioner Dominguez,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Rosatos,
Yes.
Chair Thompson,
Yes.
Commissioner Velasquez,
Yes.
Commissioner Vehil,
Yes.
Commissioner Zemlik.
Yes.
The motion passes.
Thank you. Next item on the agenda item number 4 is public comment. Did we get any requests from the public to speak?
I haven't received any requests to make general public comment. No, sir.
Anybody in the audience? All right, let's move on. We have a new member, Srikant Alagugu. And would you please introduce yourself and give us a little bit about your background?
Sure. Hey, good morning, everyone. I'm Srikant Paladgu. You can call me Sri for short. I'm the Bureau Chief for the Environmental Health Epidemiology Bureau in the Epidemiology and Response Division for the New Mexico Department of Health. I'm the Cabinet Secretary Designate for the Water Quality Control Commission. I've been with the state for about a little over 4 years now. My background, I'm a physician from India. Went to Osmania Medical College, which is the prestigious college in Hyderabad. From there, I moved on to the United States. First came to Colorado to start my master's program in public health. Then after the first semester, moved to Las Cruces, felt like home, so decided to stay back in New Mexico. Graduated from Las Cruces, came to Albuquerque, worked for Bernalillo County Environmental Health, doing some research, worked on a project with US EPA for over 6 years, then went back to school to do my MBA, and then worked in private sector for a Medicaid organization for a little bit, and then returned to my passion to do more environmental health research. So I oversee about 7 different grants through the Department of Health on environmental health topics. Here I am. Thank you for giving me this opportunity to serve the board.
Thank you for your willingness to serve. Welcome.
Thanks.
And if you have any questions, ask Larry Denise. Or keeper of all people in mind. Okay, agenda item number 6 is issue WQCC number 22-01, parentheses A. It's a permit review, discharge permit renewal for DPH 73.
Good morning, Mr. Chairman, members of the commission. My name is Andrew Knight. I am the attorney for the New Mexico Environment Department in this matter, as well as just about everything else on the agenda today. But we'll start with this one, and we filed a motion to continue the stay in this matter. It was filed with the commission late last week. It was a joint motion between the Environment Department and the Air Force, and I ask today that the commission grant the motion, continue to stay in this matter. We are engaged in mediation, confidential mediation with 10th Circuit mediator, and pending the outcome of that mediation, we request that the stay remain in place. We, would like to hear from the Air Force Council on this as well. I'm sure they would concur.
Questions?
Thank you, Mr. Knight, commissioners and board. This is Major Threats speaking on behalf of the Air Force. As Mr. Knight previously stated, we jointly filed the motion. At least from what it appears from the litigation team, mediation may be going in a positive direction, and that the reason for the stay is that simply that the issues involved at Cannon were of such a complex nature that the Department of Justice, Department of Defense, and the Air Force possibly misjudged how difficult it would be to come to a resolution through the mediation. But things are moving in a positive direction, and they'd at least want to attempt to exhaust those remedies before we possibly place the board into a position to make a decision which then may be appealed and then jeopardize those internal negotiations.
Mr. Dominguez.
Mr. Knight, just to place it on the record, the request for stay was for 90 days, is that correct?
That is correct.
Okay, thank you. Thank you, Mr. Chair.
Mr. Chair, would that get us to the October meeting? don't want to state it, and the day before a meeting. Yeah, I haven't done the math on that myself. I don't know actually the date off the top of my head.
October 10th is the next meeting, the October meeting, excuse me.
Yeah, why don't we make the stay until the October 10th? Instead of 90 days, just to October 10th? It certainly seemed to make more sense to me now that I hear it. Sure.
Mr. Fritz, are you agreeable to extending the stay to the October meeting, which is October 9th?
10th.
Yes, sir. Yes, sir, I am.
We don't need to vote on this, do we?
Yes.
Okay, is there further discussion? Then we need a motion to accept the petition to stay. A motion.
As amended.
As amended.
As amended.
Sorry, thank you. And to clarify, we're on item 7 on the agenda, correct?
6.
6. Item 6 is the report, and item 7 is the action item, it looks like on my agenda. Both for DP 873, just to make sure that we're dealing with both. But yeah, either way, seconded.
If I may, Mr. Chairman, to me, item 6 and 7 could certainly be consolidated or be considered that way. And if the commission grants the motion, then there would be no need for the commission to deliberate or take action because stay would remain in place.
Thank you. Further discussion? We ready to vote? Okay, this will be a roll call vote to grant a stay of proceedings until October 10th. Joe, roll call.
Commissioner Armstrong, how do you vote?
Yes.
Commissioner Brankard,
Yes.
Commissioner Dominguez,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Paladugu,
Yes.
Commissioner Rosatos,
Yes.
Chair Thompson,
Yes.
Commissioner Velasquez,
Yes.
Commissioner Vehil,
Yes.
Commissioner Zemlik.
Yes.
The motion passes.
Good, thank you. Next is agenda item 8, which is WQCC 22-31, Mexico Water Protection Division Groundwater Quality Bureau versus El Paso. This is a request for hearing. So I'm not sure if someone from the Groundwater Bureau, Mr. Knight.
Thank you.
Yes, go ahead, Mr.
Thank you, Mr. Chairman. Again, I'm Andrew Knight. I'm an attorney for the New Mexico Environment Department, and I represent the Water Protection Division and the Groundwater Bureau and the Surface Water Bureau in these 2 administrative compliance orders. These orders were issued to El Paso Water, which is a water utility in Texas, for discharges into New Mexico. The matter, let's see, I believe we requested a stay because the federal court in the Western District of Texas is entertaining a declaratory action regarding both of these compliance orders. And this action was brought by the utility against Secretary Kenny and John Roderick in their official capacities. And the purpose of the declaratory action is to, they assert that the state of New Mexico does not have jurisdiction to enforce in this matter. So the status of that federal litigation in Texas is now that I have filed a motion to dismiss under 12 federal rules. And that motion is pending with the federal district court in Texas, and we are waiting for the court to rule on that motion. So ask that the commission continue to stay this matter until the federal court, at least until the federal court rules on that motion to dismiss. If the motion is granted, then we would ask the commission to proceed at that time with setting a hearing, but for whatever reasons, the federal court is taking a fair amount of time to decide this motion to dismiss, so stuck until the federal court acts on that motion.
Questions? Concerns? Commission? So you're requesting basically an indefinite stay?
Yes, that would be my request. And if the commission decided to grant a stay of a specific amount of time, then, certainly wouldn't have any objection to that either. But in order to prevent me from having to come before you repeatedly, or it continues to take time to rule, then I would say, if the court was, or if the commission wanted to grant a stay of a definite amount of time, I would recommend 180 days. That's just my recommendation, but the commission can certainly do it as he said.
Yes.
Mr. Chairman, this is Tom Nasco. I represent El Paso together with Stephen Weller, who's on the Zoom call from Austin, Texas. May I comment on Mr. Wright's response?
Yes, please.
Thank you, Mr. Chairman, members of the commission. Mr. Knight is correct that the matter is currently pending in the federal court in Texas, but there are federal jurisdictional issues that have to be resolved by the court. And hearing officer Chikalian has entered an order staying the matter until those matters are resolved. So I don't think it would be appropriate for the commission to set any timeframes. As I understand the agenda, this is a status conference that the stay order is in effect until the federal jurisdictional issues are resolved. And I'll turn it over to Mr. Weller, who's my co-counsel, but he's in charge of the federal litigation, and he is anticipating a motion for summary judgment in federal court on those issues. So I think we would recommend that the commission simply defer the matter, and we will meet regularly with hearing officer Chikalian concerning the stay, but we do think that the federal court has to resolve these issues before the commission can take any action. So I would urge the commission not to adopt a time frame, but simply to let the federal litigation resolve itself. But with that, if I may, Mr. Chairman, I'd like to turn it over to Mr. Weller for any additional comments he might have.
Okay, Mr. Weller?
You're muted, Stephen. Hey, Stephen, you're muted.
Okay, can you hear me now?
Yes.
Okay, my apologies. Thank you, Mr. Nasco. Thank you, Mr. Knight, for the introduction, and good morning to everyone. Yes, my name is Stephen Weller. I'm an attorney for the El Paso Water Utility. And we do have, the matter is pending in federal court in the Western District, the El Paso Division in Texas. The utility is questioning whether INMED has the jurisdiction to issue a compliance order effectively attempting to govern matters in Texas. And it is our position that is a matter that is within the jurisdiction of the TCQ. and the EPA pursuant to the Federal Clean Water Act. There is clear authority from the U.S. Supreme Court on that point. There have been a number of cases analogous to this one where the court has determined that the appropriate measure and measures to be taken are for the state where the discharge is located, which is referred to as the source state, to be the jurisdiction where the matter is handled. So we filed a complaint in federal court on that basis. We're moving the case forward as quickly as we can. My client is motivated for that matter to be pressed forward so we can reach a resolution on those jurisdictional questions. InMed has indeed filed a motion to dismiss, but it's based not so much on whether a federal court can adjudicate that question, but whether the federal court that reviews it is in Texas or in New Mexico. So even in the event, we think the unlikely event that the case might be dismissed from the El Paso court, we intend to immediately refile it in a New Mexico federal court. So respectfully to the commission, we would echo the comments from Mr. Nasco and I believe from Mr. Knight that that the best course of action would be for the matter to remain in a place where it's been stayed, which is what the hearing officer has done, has determined should occur. And we are reporting to him periodically. He is monitoring the case. But with that, I don't believe we have anything further to add, and I appreciate everyone's time this morning.
Thank you. Mr. Dominguez.
Thank
Chair
you,
Thompson?
Just to recap a little bit of the history on this regarding the stay. If I'm remembering correct, the hearing officer issued a stay that actually did not have a deadline on it, and I'm going to lean on our hearing officer to verify that. The point being, if the hearing officer has already issued a stay that is somewhat dependent on the outcome of the federal court, then there's not really an action that the commission would need to take regarding the stay, because there's still a pending stay that the hearing officer previously issued.
Mr. Sanchez, I'll give you an opportunity in just a second. Mr. Chicalio?
Commissioner Dominguez is correct. I am monitoring this case in federal court. As soon as it's resolved, it'll come back to me and we will continue the adjudication process under 20.1.3 NMAC in this matter. So I'm on top of it. We have a status conference August 1st to review what's happened so far. Thank you.
Thank you. Mr. Sanchez?
Thank you, Chair Thompson. Chair Thompson, members of the commission, Commissioner Dominguez is correct. I'm looking at the order that was entered by Hearing Officer Shikalan on September 9th of last year, and the decretal portion says, it is therefore ordered that the above styled actions, they've been consolidated. This item we're now discussing, the one following, shall be stayed pending resolution of the federal action. I think that language as it stands is sufficient. This item was in the agenda just as to inform the commission as to the status of the proceeding. I agree with Hearing Officer Kagan that the commission does not need to take any formal action on this particular agenda item or the one following. Thank you.
Okay, council's suggested we don't need to take any action. Any thoughts from the commission? Schreiber.
I guess my only thought is that when we've delegated this to the hearing officer, he obviously has a process of keeping up to speed. And I assume he put it on the agenda, so we would be informed about what's going on here. And that's the only, once or twice a year, you can pop this on the agenda just to let us know what's going on with this case. Or send a memo to us. It doesn't matter.
Good. Is there further discussion on this one? All right, let's move along to, agenda item 9, which is 22-31, which is request for hearing and answer, respondent El Paso Water Utility.
Yes, and thank you, Mr. Chairman. Yeah, this is the same case as the commission just discussed. There was a groundwater compliance order and a surface water compliance order. So this is covered by the same order from the hearing officer. So there's no need for any action by the commission on this case either.
Okay. Is everybody in agreement? Let's move on. We're doing great this one. Agenda item 10, which is WPC numbers 23-12 and 2313, which is appeal petitions for review of OCD division permit requirement determination. So I'm not quite sure who's leading this discussion. We don't have anyone from OCD here.
But, Mr. Chair, you have Jesse Tremaine from the Oil Conservation Division.
Yes, would you go ahead and summarize what's going on, please?
Yes, the parties, both petitioning parties and the division have, utilized the stay to meet and discuss the issues at hand, and have come to the determination that the appropriate next step is like in 2255 through 57, where we want to request a remand to the division and assigning of a hearing officer so that the parties can continue to discuss the matter and development of a factual and administrative record. Mr. Rankin, did I summarize that appropriately?
Mr. Tremaine, indeed you have. Mr. Chair, we would agree at this point, the parties have essentially, at this point anyway, exhausted their efforts to try to resolve the petition without recourse to further development of factual record. So at this point, we think it makes the most sense to follow the same path as the petitions that preceded us and to remand to the division for continuing discussions and development of a factual record.
Okay. So this is a request to remand the decision by OCD to issue a permit. Questions or comments? So this affects both 2312 and 2313, I assume. Is that correct, Mr. Tremaine?
That is correct.
Thank you.
For the other parties here,
I think they're the same, aren't they?
Yes, Mr. Chair, Holland and Hart is representing both parties, both petitioners in these cases.
Okay, so if we're going to remand, will we need, I guess this is a question for Council Sanchez. We're going to remand, does that require a motion from the commission?
Chair Thompson, this matter was on the agenda pursuant to an order that was entered by the commission on May 4th, and what it required was that the parties appear for a scheduling conference today at today's commission meeting. If the commission will recall, It chose not to appoint a hearing officer. So that's certainly a question that's been raised by comments made by council. And so the only other thing is I don't see a docket yet, but I think Mr. Tremaine filed a motion saying that they needed more time to develop the record. As the commission will recall, this came up on essentially a letter from the OCD director, and there was no record developed as such, so we're kind of working backwards here. I don't see a motion for remand. That may have been in one of the earlier pleadings, but before the matters today are the status conference that's referenced in the prior order and the very recent filing by Mr. Tremaine that I don't see docketed yet. Thank you.
Chair, if it would please the commission, I believe what Mr. Sanchez is referring to with my latest filing, there was a very late filing made yesterday with the other parties in the preceding cases to extend the deadline for submission of that record, because I have been out for over a week attending to a very urgent family medical issue, and I will be traveling again for hopefully a short period of time. So I don't believe that there has been a recent filing made by the division in 2312 or 2313. We're here today making a verbal motion to remand.
If I may just add as well, Mr. Chair, as part of the initial petition in both these cases, petitioners had requested, due to the lack of a factual record, for a remand pursuant to the statute. So if you're looking for a formal request, it was made initially in the petition for both these cases.
Okay. What's the pleasure of the commission? Seems like a motion to remand the situation, the request is appropriate.
Question, Mr. Chair. Would that also encompass assigning a hearing officer within that same motion?
I don't know. Would the hearing officer be representing OCD or representing the Water Quality Control Commission?
The Water Quality Control, the commission, Mr. Chair.
Okay. So, Mr. Dominguez, do you have a recommendation?
No, that was actually a question. I'm trying to determine whether a hearing officer is necessary at this point in time, or if just the remand addresses the situation. Something needs to occur today because, as I recall, the current stay expires today. Please. Some kind of action has to be taken. Okay. If the remand addresses it, then I'm fine with that.
Looking to the commission for suggestions.
Mr. Chairman, this would be a remand to the oil conservation. So it would be no longer a proceeding before us. It would be up to the oil conservation division to not only develop a record, but issue a decision based on that record, which could then be appealed back to us. See nodding from the attorneys. That's what the matter would be out of our hands. It would be back to the Oil Conservation Division. They would develop a more formal record on this matter and a decision based on that record, which we then could review if needed be.
And if we took that course of action, we wouldn't need a hearing Would not be a hearing.
Mr. Chair, given the input from Commissioner Brankert, I would move that the commission remand WQCC 23-12 and 23-13 remand back to the Oil Conservation Division.
Second. Got a motion and a second. Is there further discussion? We ready to vote? Okay, so we've got a motion before us to remand this permit back to the, yes, there's two issues actually, 23-12 and 23-13. We remanded back to OCD for collection of further information, and this will come back before the commission at some point after that's been resolved. Ms. Jones, would you call the roll?
I will.
Chair
Commissioner,
Thompson,
Hold on. Yes, Council Sanchez.
my apologies for the interruption, but just for clarification, I ask that the motion be clarified that the commission is voting to remand the matters back to OCD for development of an administrative record. Just so we're clear about what that remand is specifically. Thank you.
I was struggling with my recapitulation or description of the request, but thank you. Okay.
Commissioner Armstrong, how do you vote?
Yes.
Commissioner Brankert,
Yes.
Commissioner Dominguez,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Paladugu,
Yes.
Commissioner Rosatos,
Yes.
Chair Thompson,
Yes.
Commissioner Velasquez,
Yes.
Commissioner Vehil,
Yes.
Commissioner Zemlik.
Yes.
The motion passes.
Thank you all. Thank you, council, for both organizations. So, Mr. Knight, we're looking to you for guidance and clarification on the Supreme Court decision in the Sackett ruling.
Oh, I believe that is.
Oh, I'm sorry. Okay. Item number 11, which is WQCC 23-31, parentheses A, Cannon Air Force Bases, review of any determination that a discharge permit is required for their pilot plant. Thank you. I'm sorry.
Good morning, Andrew Knight again for the New Mexico Environment Department, Office of General Counsel, and I do represent the department in this matter as well. This matter is consolidated with the other matters involving Canon that are before the 10th Circuit in mediation. So this matter is also covered by stay. So there is no need for any, well, no, I guess there was, I believe, a kind of a companion motion to continue stay. There were two motions filed. I believe this was the second one. And I believe that, let's see, I believe the commission would need to vote to grant this second motion, but it is covered by the same facts and the same explanation as the other motion to stay.
Okay. And the Cannon Air Force Base is represented by Major Threats.
Major threats, sir. Yes, sir. Similar to what Mr. Knight reiterated, this is almost a companion case. It involves one of the issues which we appeal within the DP 873 appeal, and it's also within the 10th Circuit as part of that mediation. So as was appropriate for the last case filing, I believe it would also be appropriate here just to give the federal litigation team and InMed an opportunity to possibly come to a resolution that benefits all parties. Over, sir.
Okay. So we have a request to stay these proceedings. Is there discussion?
Mr. Chair, just make sure that we have it clear on the record. This would encompass both WQCC 23-31 and 22-01. Is that correct?
Mr. Chairman and Commissioner Dominguez, there were two separate joint motions filed, and the commission has granted one of those, and this is the other one. Yeah, fairly sure on that. Major Threats can correct me if.
No, you are correct, Mr. Knight. This is the second motion on the companion case.
Okay, and in the preceding one, we moved to stay until October 10th. Our regularly scheduled meeting in October. Is that similar motion for this agenda?
Mr. Chair, I move that we stay 23-31 until the October 10th meeting.
Thank you.
I'm sorry, I didn't catch the second. Commissioner Paladugu? Okay, sure. Thanks.
Okay, so it's been moved and seconded to stay these proceedings 23-31 until our October 10th meeting. Ready to vote? Jones?
Okay. Commissioner Armstrong, how do you vote?
Yes.
Commissioner Brankard?
Yes.
Commissioner Dominguez?
Yes.
Commissioner Fry?
Yes.
Commissioner McWilliams? Commissioner Paladugu?
Yes.
Commissioner Rosatos?
Yes.
Chair Thompson?
Yes.
Commissioner Velasquez?
Yes.
Commissioner Vehil?
Yes.
Commissioner Zemlik?
Yes.
Motion passes.
Good, thank you. And now we go to agenda item 12, which is an update on the Supreme Court's decision in the second case.
Yes, Mr. Chairman.
I'm sorry, excuse me. Okay. Mr. Dominguez.
As much as I was wanting to keep moving forward there, I'm jumping back to WQCC 22-01. So there was, correct, that there was also a joint motion to extend the stay on 22-01.
Yes, that was the first motion that the commission acted on this.
Read this way. Okay, thank you, Mr. Wright.
Okay.
And
Thank you, Mr. Chair.
regarding the next agenda item, I will be, much as I could talk about Saget all day, but I am going to allow our Water Protection Division Director, John Roderick, I believe is online to give that presentation.
Okay. I don't see his name.
Oh, I'm sorry. It's our Surface Water Bureau Chief, Shelley Lennon, is going to be doing that today.
Okay, great. See her name. We'll move us so fast. Is she here?
I don't see her online unless she's one of the call-in numbers.
Possibly Susan Lucas Kamara.
She's on.
She was on.
Susan Lucas is on the WebEx.
Okay.
I'm
Someone-
on, but Shelley is supposed to give the talk. Let me ping her.
So for water logs, there's been a lot of contention over the last 6 or 8 years on what is the definition of waters of the United States? WUS. There was a proposal, I guess it was actually enacted under the Trump administration to change the definition of waters of the U.S. and then went before the courts, and there was a recent court decision, and it has very significant implications to surface waters in New Mexico. So I requested that this be put on the agenda because there's a lot of uncertainty about what the decision means and the implications for it.
Steal the lots of sure.
Oh, yeah. I tell you what, let's take a 10-minute break. We will reconvene at 10:50, 10:55, 10:55. Sorry. Okay. Let's reconvene. And I see that Ms. Lemon is online now, so thank you, Shelley. We're on agenda item 12, which is an update on the Clean Water Act decision, Sackett versus EPA. And so Shelley, come over to you.
Thank you, Mr. Chair and members of the commission. I'm Shelley Lemon. I'm the Bureau Chief for the Surface Water Quality Bureau. And I'm here today to talk to you about the Clean Water Act, waters of the United States, and the recent Supreme Court decision on Sackett versus EPA regarding Clean Water Act jurisdiction. Let's see. So my basic outline for today's talk, first I will talk about the scope of the Clean Water Act and then provide a brief history of the definition for waters of the United States, and then discuss the Supreme Court decision regarding the Sackett case and possible impacts to New Mexico moving forward. Oops, sorry. So in 1972, the Clean Water Act made it illegal to discharge pollutants into waters of the United States without a permit. And waters of the U.S. refers to surface waters that are protected under the Federal Clean Water Act. The purpose of the Clean Water Act is to restore and maintain the chemical, physical, and biological integrity of the nation's waters. It does not grant federal jurisdiction over all waters located within the boundaries of the U.S. However, many waters are hydrologically connected, and temporary or permanent upstream waters have the potential to impact downstream waters over a variety of spatial and temporal scales. Over time, Supreme Court decisions established that the definition of waters of the U.S. is more than just traditional navigable waters, but less than all waters. And there is currently a struggle to reconcile 21st century ecological science with the core concept of connectivity and the Clean Water Act's 19th century paradigm of navigability. Congress has declined to resolve this tension, and the Supreme Court has contributed to the confusion. All right, so as I stated on my last slide, in 1972, the Clean Water Act made it illegal to discharge pollutants into waters of the U.S. without a permit.
I'm sorry, Ms. Lemon, have you got, are you speaking from
Yeah,
slides?
I've given her screen sharing.
What's that?
We don't see any slides.
You don't see any slides?
Nope.
That is, okay, let me stop sharing. Or, a second. Do you see a slide now?
No.
It says it's sharing.
Are you allowing us to see the slides?
There you go.
There we go.
Thank you. We see it now.
Okay. Let's see. Sorry about that. All right, so the scope of federal jurisdiction under the Clean Water Act is limited to waters of the United States. However, there was no clarification of this term in the Clean Water Act. Okay. There we go. I'm sorry, I'm having technical issues with my end too, so it's interesting, and I'm hearing feedback, so it makes it a little bit more complicated. All right, so there was no clarification of waters of the U.S. given in the enacting language for the Clean Water Act, and it was left up to the Army Corps of Engineers and the Environmental Protection Agency to develop guidance and regulations to define waters of the U.S. and the scope of federal jurisdiction. And the Corps and EPA spent the next decade in the 80s working through the process and promulgated regulations to define waters of the U.S. in the 1980s. Then, in a trilogy of Supreme Court cases starting in 1985, the Supreme Court ruled on the meaning of WOTUS. And so in 1985, in the Riverside Bayview case, SCOTUS upheld the adjacent wetlands protection and said that the Corps must necessarily choose some point at which the water ends and the land begins. And then in 2001, the Supreme Court issued a decision on the Solid Waste Agency of Northern Cook County and decided that isolated waters are not waters of the U.S., even when such ponds are used by federally protected species and migratory birds. And in 2006, the Supreme Court ruled on the Rapanos decision and attempted to provide clear jurisdictional boundaries, but was unable to reach a majority opinion. And this is where the court was split, and the Scalia plurality opinion was the official plurality opinion of the court, which focused on relatively permanent test to determine waters of the U.S., and the Kennedy concurring opinion focused on the significant nexus test to determine jurisdictional federal jurisdiction. And the concurring opinion, the Kennedy concurring opinion, was what was used to determine whether a water was federally federally a water of the U.S. Up until recent debates about the definition of waters of the United States. And in 2008, EPA and the Corps issued guidance that considered Rapanos. So we had been operating under that guidance for almost a decade. Since the Supreme Court decisions, the definition of waters of the United States has swung the pendulum 3 times since 2015, depending on each administration's interpretation, and it's likely to change again through new rulemakings or Supreme Court decisions or both. So in 2015, the Clean Water Rule emphasized Kennedy's significant nexus test and looked at whether a water body contributed to the chemical, physical, and biological integrity of a clearly defined water of the United States. In 2020, the Navigable Waters Protection Rule emphasized Scalia's relatively permanent test. So a water had to be relatively permanent with a continuous surface connection to a water of the U.S. to be federally protected under the Clean Water Act. And then in 2021, the Biden era WOTUS rule was codified to put back in place what we had been doing in 2008 forward with that was updated to reflect Supreme Court decisions. But all 3 of these waters of the U.S. definitions were immediately litigated, and there's been confusion about whether a water is jurisdictional on or not through this whole process. And in 2022, the Supreme Court decided to hear the Sackett versus EPA case. In that case, Michael and Chantel Sackett had been in a legal battle with EPA for over 15 years. The dispute began in 2007 when the couple began to prepare the lot they own in Idaho for construction for their dream home. And EPA issued a stop work order telling them that they needed a discharge permit, that the wetlands were protected under the Clean Water Act. And the Sackett's latest appeal to the Supreme Court was to consider one issue, the definition of waters of the U.S. and whether the significant nexus test was the proper standard to determine the jurisdiction. Right. So in May 2023, the Supreme Court issued their long-awaited opinion in the Sackett versus EPA case, and their decision emphasizes Scalia's relatively permanent test. So the court held that the Clean Water Act applies only to wetlands that are, as a practical matter, indistinguishable from waters of the United States, meaning they are a relatively permanent body of water connected to traditional interstate navigable waters, and that the wetland has a continuous surface connection with the water, making it difficult to determine where the water ends and the wetland begins. This, as you can imagine, is big news in the world of water, which is why I'm here today. So, what's next after the Sackett decision? Right now, the EPA and the Corps are interpreting the phrase waters of the United States consistent with the Supreme Court's decision in Sackett, and they're developing a rule to amend the waters of the U.S. rule that was published this year in January 2023 that will be consistent with the Sackett decision. The agencies intend to issue the final rule by September 1st, 2023. And once the rule is final, the agencies, EPA and the Corps, will be hosting discussions with stakeholders with the goal of understanding implementation related questions remaining after the final rule is published, and also considering Sackett. So what's next? That's still to be determined. EPA and the Corps are working through it, and we will see a new rule if they meet this timeline by September of 2023, excuse me. So what does this mean for New Mexico? Although the ramifications of the Sackett decision are still unknown, we do know that using only the relatively permanent test to establish federal jurisdiction in a semi-arid state like New Mexico will result in significantly less waters being protected by the Clean Water Act in our state. Approximately 7% of New Mexico's surface waters are perennial, leaving most of our waters subject to unregulated pollution threats. And non-perennial waters make up 93% of New Mexico's surface waters. The maps, the top one with the purple shows the perennial waters or perennial stream miles, which New Mexico doesn't have very much of. And then the middle map shows the non-perennial in green. And as a nation, non-perennial waters make up 80% of our surface waters throughout the United States, and perennial waters make up 21%. Like I said, New Mexico is a little bit different. We only have 7% perennial waters. So it could impact us more. Ephemeral, as we know, ephemeral and intermittent waters deliver pollutants downstream where there is perennial waters. In addition, many perennial streams and rivers are interrupted. They lose flow in sections of their stream bed due to climate and weather conditions. And those interrupted streams, because they do not have a continuous surface connection, may not be subject to Clean Water Act protections under this new ruling. These include many source waters for drinking water and all ephemeral water bodies in our state. As a result, many construction sites in arid states may not be required to obtain NPDES permit coverage for stormwater discharges that reach ephemeral, intermittent, or interrupted streams. And similarly, many dredge and fill activities in or near waters and wetlands may not be required to obtain a Clean Water Act Section 404 permit for discharges to ephemeral, intermittent, or interrupted streams. We also know that the state of New Mexico has a definition of surface waters of the state that is more broad than the definition of waters of the US. So, without a state surface water quality permitting program, it's going to be very difficult for New Mexico to protect its waters from contamination and degradation, because we're going to be at the mercy of the federal definition of what is and is not protected, and not what the state of New Mexico wants to protect. So in other words, without a state permitting program, if waters are not protected under the Clean Water Act, federal discharge permits are not going to be required. We are working to review a potential state permitting program. It is in the very beginning stages of development, and we're looking at outreach and communication as our first phase. So we'll be doing that over the next year. And again, here are some New Mexico surface water facts, just because I like these little facts. Approximately 40% of New Mexico's population depends on surface water for its drinking water, and non-perennial flows recharge aquifers where water can be stored for current and future drinking water purposes. Approximately 45% of assessed perennial surface waters do not meet surface water quality standards at this time. As I've said before, non-perennial waters are ecologically and hydrologically significant in the arid and semi-arid Southwest. There's only a fixed amount of fresh water in the world, and less than 1% of all water on Earth is actually available for human use. So it's pretty precious. A spilled gallon of gasoline can contaminate almost 750,000 gallons of water. And compared to today, 5 times as much land is predicted to be under extreme drought by 2050. So protecting our water resources should be a major objective in this next decade. And, the economic impacts of poor water quality, these are 2 minor economic major economic impacts, but there are definitely more. Increased cost to treat drinking water because of poor water quality, and also reduced recreational opportunities because of poor water quality. I just want to remind people it's important to, when I was speaking before the commission back in October and talking about the 50th anniversary of the Clean Water Act, I stressed this point too, that it's important to remember the Clean Water Act is one of our nation's greatest successes. Waters that 50 years ago that were thick with pollutants from point and non-point sources now support recreational and economic activities and improved ecological conditions for aquatic and wildlife. And that's because the broad policy of ensuring protection for a lot of waters was a benefit to all Americans. Our quality of life has improved as a result. New Mexico should continue this broad effort to protect our precious water resources and ensure clean water for current and future generations. All right, and with that, Director Roderick could not be here today. He's actually talking with the Water and Natural Resources Legislative Committee, and Crystal Weatherly is assigned to Waters of the U.S. and our state permitting program. She's our Assistant General Counsel. She was also unavailable today. She was on travel. So with that, I'll open it up for questions from the commission.
Okay, questions? Thank you, Ms. Lennon. So if we've got 93% of our streams are surface are not perennial and are not going to be subject to the Clean Water Act, will we still have discharge permits for our wastewater treatment facilities to discharge to them? It
Only
won't
if,
be- I'm sorry, go ahead.
I'm sorry, Mr. Chair. Only if we have a state permitting program that can issue discharge permits to protect those state waters.
Do those wastewater discharges that discharge to dry oils, they also have a groundwater permit?
Mr. Chair, there are some that have groundwater discharge permits. There are others that do not. So there may be opportunity to regulate them or change their groundwater discharge permit depending on the facility and where they're discharging. There also may be opportunity to regulate them under RCRA through the Hazardous Waste Bureau. That also depends, there's an NPDES exemption in RCRA that allows, if there's no NPDES permit, then they may be subject to a hazardous waste permit. Yeah, but right now we do not have a surface water discharge permitting program. That's what we're working on looking at. We've hired Pam Homer as the lead for our state permitting program, and we're working with a contractor to develop an outreach plan. And we'll be conducting outreach over the next year or probably longer to figure out what the concerns are, to garner support for this, to figure out what a permit program would look like in New Mexico. And then we have to build capacity to actually administer and implement a program.
Let me just follow up. The Water Quality Act would allow the state to have a state discharge permit program?
Mr. Chair, yes, the Water Quality Act, we are allowed, authorizes us to have a state discharge permitting program. We may have to amend the Water Quality Act for certain parts of the program, but it allows, there is a clause in the Water Quality Act that allows the issuance of permits for discharges to surface waters.
Commissioner Dominguez.
Yes, thank you, Ms. Lemon. Chair Thompson touched on one of the questions that I had, and that was whether there would be any statutory revisions necessary to fully implement a permitting program. And you kind of straddled the fence on that. Yes, there's authority, but it might need to be tweaked. The second part then, I guess, and this is not to put you on the spot, but it's one of the questions that I get out in the field is, so if there is a state permitting program, how do you build capacity, i.e. meaning how would that program be funded?
Commissioner Dominguez, Mr. Chair, that is to be determined. As we move forward with developing a permitting program, we're going to be working with stakeholders to evaluate the scope of the program and application of a state discharge program. You know, we're going to need to evaluate how we're going to pay for it. It can be 100% fee-based. It can be 100% general fund. It can be a mixture of those two funding streams to pay for a program. Projected resources for just like a state, an equivalent state NPDES program at full implementation would be about 40 to 45 full-time equivalents, so full-time employees, and probably would run in the $6 to $7 million range. That's at today's levels, not moving forward. We also, I talked about briefly the dredge and fill program, which is under the Clean Water Act, Section 404. And that's also of concern because dredge and fill activities would also not be protected. We have not been looking at that, but a state program could implement that component as well, maybe at a smaller scale or at a different scale than the federal program. But there's a lot of resources that are involved and consideration that we need to take. One, about program development. Two, about the scope of what we want to protect in New Mexico. And three, how we're going to pay for it if the legislature is going to support that through general fund, or if it's going to be fee-based, or if it's going to be both.
Okay, thank you, Ms. Lemon. I know that's a moving target and probably not a fair question, but I'm just throwing it out there because obviously, as you currently know, the federal permits currently do not cost the regulated industry anything, so that filling that gap with the state program should be a lively discussion when you do outreach. So as a follow-up question, is the department also looking at going after primacy for the federal program?
Commissioner Dominguez, Mr. Chair, that is something that we're considering. I don't know if that is what will result from this effort or not. We need to figure out what it is we want to take over. If we want to take over the federal program, there are specific requirements, and that will require probably some Water Quality Act changes. We are looking at primacy, gaining primacy, and implementing the NPDES program in the state of New Mexico, but that still wouldn't cover the waters that are not protected under the Clean Water Act, right? The scope of the NPDES program would still be beholden to definition of waters of the United States. So if we want to protect surface waters in New Mexico, we're going to have to look more broadly at a state program that could be consistent with the NPDES program, so it's all wrapped up in one, or we could be looking at EPA still maintaining the federal program and we implementing a concurrent state program or complementary state program. That is on the table. I don't know how it will play out.
Okay, thank you, Ms. Lemon. Your political correctness is overwhelming.
I'm not being politically correct.
I wasn't expecting a hard and fast yes and no on that. I'm just probably throwing out the obvious questions that will arise or have already been brought up. So thank you very much for your input. Thank you, Mr. Chairman.
Any other questions or comments? We'll probably have you back in 6 months to figure out how the state's going to manage the situation. All right, let's move on. Agenda item 13 is the next meeting. So first of all, Ms. Jones, do we know if there's going to be many items on the agenda?
At this point, for the August 8th meeting, the only thing I have is the Utility Operators Certification Advisory Board members, the appointments.
Okay. So surface water quality, I'm sorry, groundwater quality we're going to have items before us? Oh, God.
Mr. Chairman, and members of the commission, I think it is too early to say for sure. There may be one item, but that is uncertain.
Well done. Mr. Recker?
Mr. Chair, I just wanted to bring up that, and Mr. Sanchez can jump in here. During the litigation over Commission's decision about TMDLs, the Environment Department in its brief brought up the fact that a bill was passed the last session, Sam, the governor, House Bill 142, which on its surface deals entirely with the remediation of the San Juan power plant and the San Juan line. But there's language in that bill that refers to the commission's rulemaking authority under the Water Quality Act. And I'm wondering if we can have the Environment Department discuss what they intended by that language and how it impacts us. No, whenever you're ready.
Yeah, Mr. Chairman and Commissioner, the attorney assigned to that matter is on leave, Crystal Weatherly, and she's the one who wrote the briefs, and I'm sure at the commission's request she could discuss that House bill and what we think, the implications may be at a later meeting, if that's appropriate, with some advance notice. I'm sure she would be happy to brief the commission on that.
And I'd be interested in hearing Council Sanchez's take on it also.
Okay, well, so the meeting is scheduled for August 8th.
It's August 8th, yes.
And we'll decide a week or two before whether or not we really need to have a meeting, because it doesn't sound like there's anything at present that's pressing unless the federal courts decide on those jurisdictional issues. All right. Anything else? I would entertain a motion to adjourn. So moved. I think we're adjourned. Thank you very much. So, I understand you're interviewing one of our students.